Now, let's speak to legal experts about the proceedings. I'm joined by Tyrone Maseko from T Maseko Attorneys and Marius du Toit from Toit Attorneys, who are both following the case. Tyrone, let's start with you, and I want to find out what can we expect to happen when proceedings resume now at 11:25. Tyrone is not with us at the moment. Let's take that question to Marius du Toit from Toit Attorneys. Marius, what can we expect to see happening at 11:25 when those proceedings get back underway?
Well, typically the courts take an adjournment from 11 till 11:30 for tea, and then the proceedings would commence with either the adducing of evidence. The state would then have to start to adduce evidence in proving their charges. But it could be, if this instance, I did not hear the part, Anlie, about the application for the recusal of Downer this morning. So I assume that this application still has to be brought. They would still have to go and bring it. Alternatively, if that application is not being considered, well, then the proceedings can start, because it should not have a bearing on the matter itself. It should be an issue that could be sidestepped by the court, and they can proceed with the evidence to be adduced. But I agree with you that it's quite historical that we've actually got the former president pleading to the charges, because, of course, the significance of that means the moment an accused has pleaded, only he's entitled to a verdict. And the state now has to adduce evidence. There's no way of turning back from this.
Well, let's come to you. Tyrone, are you with us now?
I am with you.
Fantastic. Let's find out from you then. Should, on the 19th of July, when we hear this section 106(1)H, the plea to remove prosecutor advocate Billy Downer, when we hear that plea or argument, is there any chance to take a step backwards from where we are today after the pleas have been heard?
No. Once a plea has been tendered, so a plea of not guilty, then in terms of our law, the trial is begun and the accused is entitled to a decision. So either the accused is acquitted or the accused is convicted. So simply put, we have to proceed with the evidence at that point. The only really question that arises now is how to deal with this technical aspect of the 106(1)H plea. Because, is the court going to make a decision before we go into evidence as to whether it agrees with the defense and upholds the argument, or whether it dismisses the argument?
And of course, the reason behind my question was that it was Jacob Zuma's contention that should Advocate Downer be removed, he should walk free, as the trial would have been contaminated. Hearing from you now that that is definitely not going to be the case. What is usual procedure if an advocate is removed during a trial?
Well, what they're saying, I think that's a huge jump that they make with the subsection 4 of that provision, because nowhere does it say that there would not have been a leading of evidence on the merits, which is the important bit here. So it simply means that you're entitled to an acquittal if you have not pleaded the two other pleas, which the one relates to jurisdiction. So the court does not have jurisdiction. But let's forget that for a moment and deal with what we're dealing with here. In this instance, the way I see it is that the court has to make a decision on this Billy Downer question, and thereafter they have to proceed with the merits of the trial. You cannot be acquitted until you've actually gone into the merits of the matter. That simply just doesn't make sense unless the state itself withdraws the charges. But in any event, and in which case there is no need for a decision by the court. But the point is that they have to proceed with the trial. I just cannot see any other way of not proceeding with the trial on the merits.
Marius, let's come to you now. The significance of Advocate Dalian Mpofu having been briefed in and now being the leader, it seems, of Jacob Zuma's legal team. We have, however, seen today a lack of preparedness to some degree in terms of paperwork being finalized, completed. We saw an omission in an affidavit there, which then had to be filled in and signed by Jacob Zuma to bring that up to date with the word "not." How do you think Advocate Dali Mpofu is faring under the circumstances, given that this is a case with a lot of history, a lot of paperwork, even the prosecuting team saying there is a voluminous amount of paperwork to get through? How is he holding up?
Well, I think the reality is any attorney that gets briefed shortly before a trial commences is always having an uphill battle to prepare himself for the trial. In a matter of this magnitude that would consist of thousands and thousands of pages, you really put yourself out there if you want to take instruction on at this late hour and say, I'm ready to proceed. Because essentially, when a matter like this has been set down for a while, the court has made it clear that the matter will proceed. The attorney can't chop and change attorneys and then come to court and say, I'm not prepared and I want a further postponement and I want a further postponement. Because there comes a stage where the court says, well, I'm not going to allow further postponements. This matter is now proceeding irrespective of who your legal representative is. So I would assume Dali Mpofu is an experienced counsel. He's been at the bar for quite a while. I would assume that he would not have taken it on if he did not believe that he has ample time to prepare for this matter and that he has ample time to carry on with the matter. So I would assume that he believes he's ready to proceed. If he wasn't ready to proceed and he took it on, that could be suicidal for the accused, because there's nothing worse for an accused having an attorney that's ill-prepared for his matter. The net result could be that your case is not properly presented before the judge, and it could have a material bearing at the end of the day of you being convicted of charges because your case wasn't properly presented.
The same level of preparedness is true, obviously, also for the prosecution. The prosecution has only so much leeway with the court to return and say, oh, we need a little bit more time to finalise this. In the event that when the 19th of July comes around and they address the removal of Advocate Billy Downer, do you think between now and then that will be sufficient time for them to address the affidavits and the pleas submitted by the defence?
Absolutely. I believe, if you get served with papers, usually there are time frames tied to it. In this instance, it's a criminal court. So I would imagine that that's more than enough time to deal with the recusal application, to properly ventilate your arguments on paper, and it will even give the accused perhaps an opportunity to maybe reply to what is answered by the state. So I believe there's more than enough time to deal with that issue by the 19th of July. That's a month and a half down the line. So as time goes, if to just use an extreme example, when you bring an urgent application, you often have to deal as an attorney with papers within a day or two. And that usually means working through the night or getting papers out the following morning. So 19 July is quite far in the legal fraternity to file papers.
Tyrone, let's come back to you quickly. We might be tempted to get carried away by the gravitas of the occasion. We've heard pleas, both parties in this case pleading not guilty. However, that's not to say that we can expect this trial to speed up or to get underway very quickly. What can we expect to see in the court in the next day or two?
Well, it seems to me that at this point, we're essentially dealing with technical bits. I mean, it seems to me that after today, there's actually not going to be a hearing tomorrow, that the matter will be postponed to the 19th of July to then deal with this suspect. I mean, remember that the challenge that they face now is they cannot now proceed with the merits, as I see it, of the plea of guilty or not guilty, so calling witnesses and the like, until they've dispensed with this question of whether Billy Downer has standing. I mean, I don't see how he does not have standing on their arguments. But they have to dispense with that question first, simply for the reason that how is the one comes before the other? How is Billy Downer going to cross-examine witnesses, lead evidence on witnesses if the argument is that he doesn't have a standing? I mean, if ultimately the court upholds that, then what would happen, or what would be of the evidence that would already been led by an advocate, which you now say actually did not have standing? So they have to dispense with this first question first. And since they intend to postpone the matter to the 19th of July, seems to me that the intervening period is actually not going to be utilized for hearings.
So from that, then, we can expect not to hear any evidence or testimony up until that decision is made on the 19th of July. We do see the legal parties, Jacob Zuma himself, the spectators all filing back into the court as they expect those proceedings to get back underway. Tyrone, just quickly, if you can, what are we expecting to hear directly now from Jacob Zuma's counsel, Advocate Dalium Mpofu?
Because I don't see what it is that still needs to be dealt with. There's been pleas have been tendered. They've even had an opportunity to read a prepared statement in terms of Section 115, pleading not guilty, and include the plea on Section 106H. So I'm not quite sure actually what they're going to deal with now.
Right, we'll have to wait and see as the court gets underway. It was my understanding a little bit earlier as a layperson that they might be going through the arguments for that 106.1H argument. We'll have to wait and see once they get in there. Certainly, the courtroom not as packed as it has been in the past. We've seen a number of supporters of Jacob Zuma arrive this morning. They are present in that courtroom. We had also seen during the course of the week leading up to today's proceedings that a number of his supporters who had been very outspoken after the previous court appearance are facing possible disciplinary measures from within the ANC for the comments made outside the court following the postponement at the last court appearance by Jacob Zuma. Those members possibly facing sanction within the ANC are Ace Magashule, he's of course the former suspended SG of the party, Tony Yengeni, and Carl Niehaus, leader of the MKVA. They are all present today, as are various provincial ANC leaders. We also saw former mayor of eThekwini, Sandile Gumede, make her arrival, not very vocal to our reporter Siphamandla Goge as he tried to get some details from her.